Welcome to HIPAA ABCs. This is Mary Lopez from HIPAA Associates. I'm going to help you understand HIPAA from A through Z. Today's letter is I. I is for information blocking. First, let's review the HIPAA access requirements. Individuals have the right to access their PHI held in a designated record set that includes their medical record and billing record. They may view it or receive an electronic or paper copy of the record or direct it to a third party. Access must be given as soon as possible and no later than 30 days of the receipt of a request for access in the manner requested by the patient. A one-time 30-day extension is permitted with notice to the individual if paper records are in storage and must be retrieved. Information blocking is a new rule that impacts healthcare providers, in addition to health information exchanges and developers of certified IT, and must be considered in conjunction with HIPAA. The 21st Century Cures Act prohibits information blocking of electronic health information, and EHI is defined the same way that electronic protected health information is defined. And it required the Office of the National Coordinator for Health Information Technology to implement provisions related to information blocking of EHI and interoperability. Information blocking is generally an action that interferes with, prevents, or materially discourages access, exchange, or use of EHI when the provider or entity knows it's likely to do so. This is a federal regulation that works in conjunction with HIPAA to make EHI more accessible to the patient for treatment and other permissible purposes, and it's not meant to require disclosure of EHI that is not permitted by HIPAA or state law. The information blocking rules prohibit information blocking and direct the provider to fulfill requests for access, exchange, and use of EHI held in a designated record set. While the disclosure may have been permissible under HIPAA, under information blocking, disclosures are required unless prohibited by state law, federal law, or of course HIPAA. It gives the patient the right to direct a covered entity to disclose its EHI to a third-party app of the patient's choice, such as to a personal health record app. There are 8 exceptions to the information blocking rule that don't constitute information blocking, providing certain technical regulatory conditions are met. Meeting an exception offers certainty that the practices will not be considered to have caused information blocking. An exception exists if it is reasonable and necessary to prevent harm to the patient or another person, if it protects the individual's privacy, if it protects the security of EHI, if the request is infeasible, if it helps to preserve overall IT performance, if it provides certain conditions such as content and manner of access, if fees are charged for accessing, and to license interoperability elements for EHI to be accessed. The Office of Inspector General has oversight and will determine penalties. Potential HIPAA violations will be referred to the Office for Civil Rights. This is your HIPAA ABCs brought to you by HIPAA Associates. Contact us for more information on this important topic and HIPAA training for you and your company. Follow us on Facebook and Twitter.